be aware that the way things are done back home may or may not be the way proceedings are conducted at the ICC. And that brings me back to my first point, which is you may have expectations on a reading of a rule of procedure, but the judge may be from very likely be from a jurisdiction that's different than yours. And you'll have to be aware of different interpretations or different underlying principles that are in the judge's minds, which are foreign to you. As well, the composition of the defense team will be important when dealing with the client. You may be from the same country as the accused, which means you would speak his or her language, be familiar with their mentality, their culture, events on the ground that led to the case. Or if you're not, you may have a member of your team, maybe a co-counsel, who is from the same country as the accused. Or yet again, neither lead counsel or co-counsel may be from the same country as the accused. That is something that should be borne in mind, because not only do you have to deal with your client, but you will need to deal with investigators, witnesses who are from the same country as the accused, more than likely. You need to have experts who will probably have to explain the political situation, the military situation, demographics, forensics, because bear in mind that the judges will probably know next to nothing about the country involved and where the alleged crimes took place. They probably have never been there. They don't understand the geography, the composition, ethnic, religious, demographic. You may not as well. And in dealing with potential prosecution witnesses, defense witnesses, investigations, your clients, you can see that those aspects are very, very different from what you're likely facing domestically in your national practice. So as a preliminary point here is that you should be prepared to shed your skin. Be prepared to learn and adapt to this experience where you are facing judges from different legal cultures than yours, prosecutors as well, and perhaps members of your team, which will be international as well, based on how you select your team, how you see the importance of having, if possible, someone on your team in the senior position who can deal directly with the client linguistically and culturally. Because language is a very, very important factor in these courts. In the experience at the ICTY, the Tribunal for the Former Yugoslavia, most often the only two people who shared the same language were a lawyer from the former Yugoslavia and one of the accused. That can be important in building a relationship with that client, building the trust, because you don't have to go through an interpreter. There's no third person present in the confidential meetings that you must have, sometimes very serious and difficult meetings you must have with your client. Again, if you're from that person's culture, you can understand their mentality, their biases, what they believe, what they think, how they see the world. And that is a huge factor in these international cases, and a huge difficulty if it's not managed properly at the early stage when you're composing or putting together your defense team. The judges will be listening in either English or French. Now, They all three may be listening in English. All three may be listening to proceedings in French. At times, you'll have benches composed of French-speaking and English-speaking judges who are listening through interpretation, who are following the daily proceedings in different languages. This is important. Well, there are several factors that are important here. When you're addressing the court, you may have to change your cadence, slow down a little bit, allow for the delay in interpretation, which typically would be, if you're speaking English, it would go into the, it would be interpreted into French and brought and conveyed to that French-speaking judge. When you're examining a witness, the same thing. You may speak one language, the witness may speak another language, which may not necessarily be English or French, by the way. And then that, what the witness says is interpreted back to you and also to the judges, again, to the judges in French or English. You should also be aware that you should try to determine how well the judges understand English or French. It may not be their first language, which may require you to be aware of the necessity to perhaps speak a little less metaphorically than you normally would, maybe reduce figures of speech, be very concrete in the way that you address the court for their sake and for the sake of the interpreters. Another important factor, just to finish off the issue of language, is the transcript which is produced. You probably will want to have someone on your team in the courtroom who is following the transcript in court to hopefully identify any misinterpretations of what is said. Now, that can be a real headache, especially when there's some very precise matters that arise in questioning and submissions. So I think it's typical that 120 pages or so of transcripts are produced per day, at least over 100 pages. Not every word necessarily is important, but when there's crucial matters that are being discussed through interpretation with at least two languages floating around, you'll want to have someone with the ability to follow that transcript and to make sure that what is being recorded by the court reporter is correct, because that will be the only record of the proceedings that matter months and months later when you come to deciphering the evidence and making submissions. So you're in an international setting where you have the two major legal systems at play, people with different domestic experiences that are brought to this international court. Be aware of languages, be aware of the backgrounds of the prosecutors in court, judges. Language is important. Establishing a relationship with the client, again, plays into the linguistics and whether or not you can speak directly to your client or whether you must go through an interpreter. Let me say a couple of more words in more detail about how you might want to look at the composition of the defense team. As I said, I think the ideal situation is to have at least one counsel, either lead or co-counsel, from the country of the accused. Because, as I said, the prosecutors and the judges will not be from that person's country. That will benefit the issues of communication and trust, I think, or building trust with that accused. So the local counsel from the country of the accused has knowledge of the events that probably gave rise to the indictment, the political situation, the military situation, the economic, cultural situation. You might also want to think about having a mixed team common law, and civil law. Because when you're trying to understand how a certain judge or prosecutor thinks in your defense room and defense meetings, it's good to have the input and the experience of a lawyer from the system you don't come from, whether common law or civil law. You'll also want to have people on your team as much as possible who have ICC experience. That could even be down to the junior level of junior lawyers or legal assistants who are familiar with the case law, the substantive law, and the way the courts have been interpreting the crimes. And also, very importantly, the case law on the procedural law, just how certain rules and certain practices have been interpreted and developed by the trial chamber to avoid the surprise of not being aware of the decision handed down 2 weeks ago or 2 years ago. So that's where the importance of your junior lawyers or legal assistants can assist you as counsel in your day-to-day conduct of the case. Also, your junior lawyers and your legal assistants who have experience, ideally, will be able to conduct the research. They'll know their way around the ICC's website and research engines. They can help you draft memos and, well, very importantly, motions. The motion practice, which is quite substantive in these courts, and knowing the precedents is something that you acquire if you have some experience, and the junior lawyers are often the most reliable sources of that, because as counsel, lead, or co-counsel, you have to manage so many things. You probably don't have time to sit down and conduct as much legal research as you'd like, or draft the motions that need to be prepared. You'll also want to, and will need, I would think, interpreters and translators, or access to these people, for some of the reasons I pointed out, but also for some of the reasons that documents may come your way through disclosure or through your own investigation that are not in a language that you understand. So again, it's a very time-consuming effort, and requires a lot of management skills from the counsel, primarily lead counsel, in selecting a team that can operate independently, but also cohesively with you and what you need. Jason, who introduced me, worked with me many years ago, or a few years ago, as a case manager. And maybe when we get into the discussion, I don't want to underestimate how important the case manager is to you in these cases, which are huge, require organization, and most importantly, easy access to retrieve information. There will likely be a large quantity of disclosure from the prosecutor's office to you. There will be case filings to organize and manage, to be able to find it, keep at your fingertips or the click of a button. There'll be your defense work product, which has to be categorized and cataloged and retrieved very quickly. You'll have you'll need consultants or experts, depending on what the charges are against your client. Remember, the judges will not know anything about the domestic law of the country that's the subject of this indictment, because they're not from there. So you may need experts on domestic law. You may need experts on constitutional law. You may need experts on police and military matters, demographics, as I said. So this team will be vital to case preparation and your ability to be a successful advocate in proceedings. So there must be a high level of trust between you as counsel and the other members of your team. Loyalty is important. I would say mutual respect for everyone, because it's a small group. You're going to spend a lot of time together under a lot of pressure. And the mutual support that is demonstrated by counsel, and particularly lead counsel, is going to be vital to any success that you have in coping with the indictment, the evidence, the client, and the chamber. So in developing a case theory or defense strategy, which I hope that it's becoming my intention here is to, when I point out all these factors that that I consider specific to international courts that we've just gone over very quickly, this will allow you to develop a case theory and a defense strategy to then build towards the proper advocacy and presentation of your case. I think, as you all know, the case theory will begin with the analysis of the indictment and determining what the prosecution must prove against your client, what your defense response is to the allegations. Much will depend on whether you're in a case with a single accused or a multiple defendant case, a joint trial. It'll be important to see whether your client is charged with being a direct perpetrator of crimes. Did he or she commit the crimes with their own hands, or are they superior authorities? Are they political figures, local political figures, a national political figure, a local commander, a regional commander, a president? In the period of the indictment, was there a de jure system in place, a de facto system in place? Was there turmoil in the country where the law was not necessarily being breached, but not necessarily being applied either because of a conflict? One aspect, I suspect, if you're English speaking, but you can correct me, most you may be familiar with the common law guilty plea, which is a possibility at the ICC. As you know, based on the strength of the evidence case, based on the strength of the prosecutor's case, and the strength of the defense response, there may be an opportunity to seek to have a negotiated settlement or a guilty plea with the prosecutor, if your client is so inclined to go that direction. That, of course, requires your assessment of the evidence and working with your client. Again, that trust and relationship that you must cultivate early on, I think, in the process. Bear in mind also that even if the guilty plea is something that you're familiar with, it may be a foreign concept to the judges, depending where they come from. And it may indeed be a foreign concept to the prosecutor based on his or her national experience. Cross-examination. If you come from a country, again, from the common law system, you're probably quite familiar with the concept and the notion of cross-examination and the way it's conducted. But then again, the prosecutor and the judges of the ICC may not be from the common law. They may not understand all the aspects of cross-examination. You may be told you can't ask a certain question in a certain way, even though it's been the way you've done it for many, many years back home. This will require you to be prepared at times to respond to an objection that you don't think is an objection, or an objection maybe posed by a judge asking why you're asking a question a certain way, leading questions in particular. Sometimes you have to get right back to basics with a judge and argue why it is that in an attempt to challenge or assess the evidence, you must have the ability to lead questions and ask questions in a certain way that you're used to, and actually be prepared to articulate some of the fundamentals, concepts that the adversarial system requires, even though it's not something that you would do very often, if at all, in your domestic system. And the scope of cross-examination is often, again, something that can be a challenge to counsel in a new environment. Again, for the reasons I just expressed, but we mustn't remember that not only are you testing the credibility of the witness on cross-examination, you may be exploring matters of direct examination or evidence relevant to your case. The witness may not have been asked about a certain area of evidence that is important to your client, that he or she, the witness, may know about. And it's your opportunity to bring that evidence out during the cross-examination by showing documents, by asking a person about certain events that person has personal knowledge of. So I think it's fair to say that advocacy and cross-examination starts on day one, when you're putting your team together to be able to understand the indictment, work with the client, work with your team, who will have huge tasks of organizing the file, educating you on the law of evidence and procedure, the substantive law, determining who your investigators could be on the ground, how you obtain documents that are relevant to you, if there are any, and to be in a position to make meaningful submissions and cross-examinations when the time comes. I don't know if that's what I wanted to say as an introductory aspect of this, my presentation. I very much would welcome your questions if you have other areas you'd like me to talk about. I would do my best to answer that or expand on some of the things I've said now.
Eugene, I'll start by saying first, thanks. It's always great to hear your perspective because you were there right at the beginning, really, of this International Criminal Tribunal practice. So you've got a great view on how this is developed. I know a lot of your previous cases were multi-accused, and I know the ICC does not have many multi-accused cases at the moment, but you left them out of the personalities in the courtroom that you need to manage and familiarize yourself with. Can you just speak about what that relationship may be like and what you see the role of counsel is, working across different defense teams?
Right. I guess typically I think there are two types of multi defendant cases that I'm familiar with. One would be if, let's just pick an example of 3 accused, and all 3 are military, but at different levels. You may have a general, and you may have the person under the general, and you may just have a soldier. Then the second example would be you could have a multi-defendant trial where you might have an accused from the political realm, the Minister of Defense or the Minister of the Interior, someone from the political, the President, and someone from the police, so the Ministry of the Interior. So 3 separate aspects of the defense structure of a country. The challenge there is that when you have co-accused, of course, you can't be pushing the blame onto or being seen or perceived to be pushing the blame onto one of the co-accused, because that would backfire. That can limit you in the way that you approach your defense. You have to be very aware of the specifics of defending the foot soldier and not trampling on the defense that may exist for the general, and vice versa. So the same is true of defending the politician. You don't want to go over and affect the Ministry of the Interior or the Ministry of Defense or their representatives, some military officers or police officers. So that's another very important element that you have to manage as counsel in these cases. If you have more than one accused who may be related or may not be related, and just how far the parameters can go. I suppose there's importance there of working with trying to understand the defense of the co-accused. But then again, you must bear in mind that you're not necessarily going to go to trial. There's always the chance of a guilty plea of one of the other accused, who may in turn offer evidence against you. So you're treading quite lightly here in trying to work with the other teams, bearing in mind what the evidence would be and how you would not want to obstruct them, and you would not want them to obstruct you in your ability to defend yourself. The second it becomes cutthroat, it's a holiday for the prosecutor.
No, thanks very much for that perspective. Is there any other questions we can take now, or if not, I'm sure we can find something else to speak about.
I have a question. Where typically are the accused physically during the litigation, on the way to trial?
They have to appear for their initial appearance in the court in The Hague. Then there's the possibility of getting released, provisionally released in the pretrial phase. That's not automatic. You make a submission. The prosecutor may oppose it. The prosecutor may not. And during the pretrial, before the trial begins, the accused may be back home, or quite often they're not given any kind of provisional release pre-trial, and they spend their time in detention in The Hague. And I'm sure that it's a very long process, right? The pre-trial phase can be quite long, a year or two. The trial can be a year or two. Then deliberations before the judgment can be a year, 18 months. So it can be a very long process for the accused, for the counsel, and your team. Which, again, as I emphasize, the importance of thinking carefully about selecting a team that is appropriate to the nature of your case, your accused, the experience of your colleagues on your team, from the junior people to the senior people, can really make your life easier and provide a better defense for your client. So that means if your accused is sitting in detention in the pretrial phase as counsel, you're spending a lot of time in the prison with that person. And if you don't have a common language, you're coming with an interpreter. It's cumbersome. It's slow. I don't think the accused necessarily speak as freely in front of a third person. I can see that as a problem. It's not one that I faced, because I worked with people who either the accused and I spoke the same language, or my colleague from the former Yugoslavia was the one who dealt primarily with the accused, and people back home. If the client says, "Well, go and speak to these three people They can help you. They can direct you in this direction to find documents, or they know who you should go and interview to hear my perspective and present, to develop evidence for us. Again, ideally, you don't want to be going through interpretation, because that makes every meeting 3 times longer than it has to be. So.
Thanks, Eugene, and thanks for that question. I think we'll go with Alexis and then Sharvi, and then Rick has a question, and we'll try to
Sure.
rotate around to the questions that came through the chat as well. So, Alexis,
Sure.
the floor is yours.
Thank you, Jason, and thank you, Eugene, for the very interesting presentation. My question is about the process of cross-examination in court. I mean, according to the court rule, what type of questions are allowed and what type of questions are not allowed? You mentioned something about lady questions, maybe, yes, out of subject, or I mean, it's different than the national systems.
Right, and that can be a big challenge because the first, let me talk about what is typically understood as the scope of cross-examination. You're certainly allowed to cross-examine the witness about the subject matter that witness is discussing. You're certainly able to cross-examine a witness to test their credibility, their honesty. If the person's been convicted of, I think an easy example, if the person's been convicted of perjury 5 times, you want to bring that out so the judges might see that this person may not be a very honest or credible person. But credibility doesn't always mean that the person is lying. Sometimes the person could be mistaken, right? You could say they thought that so-and-so was at a meeting on June the 6th, and you say, well, I have a document that shows that you were at this meeting, witness, but my client wasn't. So he may not be lying about it. He may have forgotten or been mistaken. So it's still credibility. And the third area would be to present evidence or to extract evidence from a witness that's beneficial to your case. Again, that could be if your client's a military person and the witness is a military person, you might want to show that person a number of orders, the witness, that he's familiar with, which are beneficial to your case. Just another easy example. Now, the problem of cross-examination or leading questions, that is really something you're going to have to come to terms with your bench. If your judges are unfamiliar with the adversarial cross-examination system in their practice, they might not like it, or they may not understand the dynamics of it as you do, or maybe you are learning cross-examination or going into the adversarial system for the first time yourself. But typically a leading question is a question to which the answer is yes or no. You don't ask the person, what's your name? You say, your name is John Smith. Yes. And you can lead this person, you're speaking, and that person is basically saying yes or no often. So you're putting words into their mouth, which is admissible in the classic common law tradition of cross-examination. Now, just be aware that depending who's on your bench, they may or may not like that, and they may try to stop you from doing it or allow you to do it for 10 questions, and then the 11th one, they didn't like it. You face that more than once, and then you have to make a submission to say, well, it's cross-examination. I have the ability to lead the witness. I submit that I'm allowed to do that. I would make a request to be able to ask the question the way that you want to. And if they object, well, then you have to be quick on your feet and get to that point by reformulating a question in a different way. So it's always, you have to be aware that that's going to jump out at you, because you and the judges are from different worlds sometimes. And uh, having a philosophical answer ready for why you would need to do it, and resorting to finding a different way to skin the cat is a way that you have to react to that. But it's a very important aspect, a good question. But you'll get a feel for that before the trial starts. But learn who your judges are, learn who the prosecutor is. They may make objections that would surprise you or not. And working with your team, if it's a mixed team, that can be a big plus as well. You can learn from each other before you step into court. Thanks.
Sharvi, did you have I believe you had your hand raised after Alexis?
Yeah, my question has been answered. Thank you so much. I'm so sorry.
No, grand. Rick, I think you're up.
Yes, hi, thank you. Thank you, Jason. Thank you, Eugene, for your very interesting perspective on everything, specifically international criminal law, of course. Now, my question is, and I'm maybe talking for all the youngsters here, how did you get involved in the early days of your career, ICTY trials, etc.? Because I believe you're an American, if I can guess your accent more or less correctly, or British?
Almost Canadian. Almost
Okay.
the 51st state. Yes.
Almost 51st state, so that's great. So can you just talk us through very shortly, of course, because I don't think we have the time. So how did you get involved and how did you get started? Because of course today you're talking about composing your team, which is of course very nice and ideal. But I don't see myself as a 39-year-old, very experienced, but just national criminal lawyer. Tomorrow, having the luxury, maybe it will be, but not really. I think it's realistic to have the luxury to compose my own team because some international president just got on the phone and wants me to help him or her out.
Right.
So maybe you just get a grip of how did everything get started on your end, and what are your tips and tricks for the generations to come?
Right.
Thank you.
Well, it was 1996. All right. There had been one trial had been completed at the ICTY then. I think there was one or two trials that were ongoing. The way I got involved was may or may not be interesting, but I understand your question, but it's completely irrelevant to what's going on today, 30 years later. It was just out of the blue. A friend and colleague at the tribunal said that there's a lawyer from Sarajevo who needs a co-counsel on very short notice. He knew I was available. He told me the trial would last about 4 to 6 months. Would I come and do it? They were looking for people. There was no. I think I was the sixth lawyer who was designated at the ICTY. So it was early days. The 4 to 6 month trial lasted 18 months, and I stayed 20 years. No, in short, that's it. I mean, now I know it's so different. I mean, there hadn't been any trials since the end of the Second World War. There was no case law. There was no procedural law. Nobody in the courtroom knew what to do next. We just had to work it out. We had to argue it, and everything imaginable was being debated. But how do we get started? It was just like that. No one knew international criminal law. No one studied it at university. It didn't exist, really. It's a theoretical thing that happened in Nuremberg and Tokyo. So it was just being at the wrong place at the wrong time. So I'm sorry I can't help you there.
Okay,
now
thank you.
It's so developed. I mean, you have lawyers, you have junior lawyers, you have research assistants, you have bodies, think tanks, universities, people who studied international criminal law going back now probably 20, 25 years at universities, master's degrees. I'm sure it's not easy to get involved. And there's a huge list of lawyers, as you know, at the ICC. So, 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 so,
Okay, maybe another question then,
Yeah.
because the last, yeah, sorry, Jason,
No, no.
just to hijack this incredibly interesting
No.
education. But okay, so you can't help us out there. I fully understand. However, you must have composed many teams. How do you go? Because you already talked about this in general, like you have to be aware of this or this or that. But in practice, how do you go about this in the last two trials? I mean,
Yeah. There, I always had either as lead counsel or co-counsel. There was always one of the two of us who was from the country of the accused for managing the accused, for dealing with events, who's aware of all the events back home during the war, during the conflict, who can pick up the phone and phone somebody back in their city, back in their country, say, contact so-and-so, your investigator, and see if you can get information about this and that. If you don't have that, I honestly don't know how you can conduct these trials. You're sitting in The Hague. The country where the events happened is, thousands of kilometers away. You have to also, I think in today's context, as I said, there's so many young people who are educated and aware of the case law and have worked in other trials and can be available to join your team. But the key thing is to have one lawyer who is from the from the country of the accused, who can deal with the accused and all the events that are going to pop up, especially if all the documents from the country are in a language other than the one you speak. It's crucial.
okay, thank you.
Yeah.
I'm
So
so sorry, Jason.
Oh,
I'm so sorry, Jason. This is just a follow-up to his question, if you don't mind.
yeah, sure.
So I did study international criminal law from NYU, and one of my favorite professors over there was Justice Theodore Meron, and he taught me so well. But even he said the same thing, how he entered into the systems. But the point is that whenever I do apply for an application, this is the feedback that I usually get, that my application is mostly academic. And if I really wish to enter into the system, I have to build up some skills. Can you suggest what skills should I maybe build in the early career position so that there isn't? I think this is also what he meant when he was asking his questions, kind of. What skills do we really need to be in the team?
But are you practicing law domestically?
At the moment, yes.
Yes.
I was working with the UNDPO prior to this through a fellowship, and then now, very recently, I have started working again in the domestic system.
Well, I think that's the trial experience, actually being on your feet, dealing with prosecutors and judges. Isn't that much different in domestically or internationally. The aspects I'm talking about, legal cultures and language, that dynamic is going to be specific. But if you've made submissions and examined witnesses and cross-examined witnesses and drafted motions and made submissions on those motions, that's precisely what goes on in these courts as well. I think the challenge is there are so few cases now, and so few courts. I mean, going back 25, 30 years, there was the ICC, there was the ICTY, the ICTR, Sierra Leone, Timor, Cambodia, then the ICC, then Lebanon. There was work. There was much more work than there is now. And you weren't getting sanctioned if you worked there. So I suppose the biggest challenge is there's so many qualified people, academically and professionally, and so few cases. I'm a bit out of the loop. I can't really answer your question specifically. I don't know precisely what's going on at the ICC in terms of getting yourself known to a potential defense team. And I'm not sure how that dynamic is working now. the defense team they're talking about, going back to your colleague's previous question, there were 2 lawyers per team, and there were no interns. There were no legal researchers. There was, we made our own photocopies. It wasn't the digital age. Things were done by fax. There were no mobile phones. It was a different time. Everything was in hard copy. It was very, very early days, and no one was qualified because no one had any experience in international criminal law or international humanitarian law. Some academics, like you mentioned, Judge Maron, but he was steeped in academia, not in practice. Right? So it was really early days, an interesting time, because none of us knew what superior authority meant, or the elements of genocide or crimes against humanity. It was all just starting. So I understand the frustration and the difficulty you probably have, given that there's so many qualified people in so few cases. I wish I could say more, but it went from a very busy field to a very quiet one, it seems.
Yeah, no, thank you, Eugene. Those are very good points, and maybe it's something that the ICCBA can try to organize for colleagues who are continue trying to break in, or colleagues who are coming to the end of cases and looking for further work. So no, those are good points, Sharvi and Rick. Luis, I think you had one more question for us.
Yeah, I have 2 questions.
Okay,
sure.
So the first one, you said in the beginning that it's important to try to figure out if the judges in front of you are from either a civil or common law country, so you can predict how they will act in certain aspects.
Right.
But aren't there procedural rules book in which the judges must follow regardless of their background?
Yes, but it's the how they interpret and want to apply those rules. I'm not suggesting any kind of dishonesty or that sort of thing, but if you're a judge, I mean, I can remember having a judge from Nigeria, Pakistan, and Costa Rica. Well, okay, all 3 competent people, but that's a pretty broad range of legal experience, and there'll come a time when I would think that I could ask a certain question, proceed a certain way, object at a certain time, or not object. The rules are there, but they will sometimes we're surprised by us, the defense counsel, and we were surprised by them because they're used to the way things are done there. I don't know how trials are conducted in Pakistan, Nigeria, or Costa Rica, but they would react at a certain point based on their own experience, and believed and in good faith believed that they were just interpreting the rules of procedure. So it's a growing process. It's certainly, and especially, as I said, if you're at a case of the ICC and it's the judge's first case, and they've just come from their home jurisdiction and haven't seen how the dynamics of a international trial go, you have to be quick on your feet as a lawyer to adapt.
And what should you do when you are in front of a situation where you should act in a certain way and you can act in a certain way, but you are restricted by the judge interpretation?
Keep your cool, right? Stay calm. And my experience too, I always work with people who are from my background's common law, the civil law system, and we would always try to discuss how would it happen in your country, or how would it happen in my country? Always being aware that out of the blue there'll be a point where you're surprised and you're on your feet, and it's very important. You just well, sometimes you lose the point, right? But you're always trying to tell the judge that it's the fairness of the trial, the fairness of the proceedings, that what you're trying to do is consistent with the rules, and you ask for your interpretation of that rule, or some leniency in what you want to do, and then they'll see that it's not. It'd be unfair to the accused not to allow you to do that. It's hard to answer in the abstract like that, but preparation, and be ready for surprises when you don't expect them.
So, and my second question is, are there any strict rules concerning the counsel's communication with witnesses? This applying for the counsel and also like for the office of the prosecutor?
Right.
Because in certain jurisdictions, it's not allowed to instruct
Right.
or
I think that's why you want to have your investigator in the field making that initial contact with witnesses, and if statements are made, they're made by your investigator. Keep that distance between the counsel and the witness. Jason, I believe the Office of the Prosecutor has developed guidelines on how they deal with taking witness statements.
Yeah, you're right, Eugene. And Luis, there's all sorts of different practices, good practices for, how to get the best information out, and different sort of methods you may want to use from an investigative perspective. And then once you get into trial, once your client may be arrested, or once you've been assigned as counsel, there's different protocols which each court have in place. It still allows for what we call proofing, when you're able to speak to a witness before they take the stand, almost as if you are, in effect, checking their story over. But that has to take place under certain guidelines. For instance, even at the Kosovo tribunal right now, the prosecutor gets to sit in on any proofing sessions you have as a defense counsel. So each court has various ways that they've crafted these rules to protect victims and witnesses. And so from my experience, I would certainly want to make sure I was doubly checked out on all those, because it's very easy to slip up and make something which may look like contempt to someone. Especially the courts there are very trigger happy now to look into those. But Eugene's initial guidance, I think, is the best, which is to keep it at an arm's distance, to run it through an investigator. I mean, you saw recently in the Saeed case, they tried to call a defense counsel as a witness, and I think that was a non-starter for many, many reasons, but certainly because of all the different risks that would fall out of that. So, but certainly I think the ICCPA or CSS would be a better source for if you had any further follow-up on that. We'll take
Thanks.
one more question from William Booth, and then I think we'll be out of time.
Thanks, Eugene and Jason. Thanks very much for the presentation. Just for the record, I'm from South Africa. So the interesting aspect relating to interpretation. So I've been very active in South Africa with regard to presentation on issues of the International Criminal Court, attended quite a few. In fact, went to Maputo in Mozambique when they became signatories to the Rome Statute, just as a little bit of background. But we have 12 official languages in South Africa. English is the language of the court. And then in addition, there are a great number of Africans who've come to South Africa. So you can imagine how it goes in the criminal courts, where although English is the language of the court, you might have a witness who has to speak one of the 12 official languages in the country. You might have somebody from Zimbabwe, Nigeria, Ethiopia, or whatever. So the issue of interpretation is, I think, obviously quite relevant in the ICC. And we've had certain cases which have determined where the interpreter wasn't sufficient. Those cases have been set aside by our higher courts because the interpretation wasn't properly done. So I think you raise it correctly, Eugene, that it is a practical problem, and particularly if you've got people from different countries as accused, you've got from judges from different countries. I think it starts becoming quite a significant problem. So that's just one aspect I just wanted to highlight. The other is, you've been asked by some of the other participants about selection. What is the selection process? You said there are not so many cases. I think, if I may just add, there are not so many cases because people are not being arrested. So you have international warrants, but the countries are either not signatories, or the countries where that particular person might go is not being arrested. So in South Africa, there was a very prominent with regard to al-Bashir, who actually came into the country. South Africa is a signatory to the Rome Statute, as you know, came into the country, but he was not arrested. In fact, the case went to court, and one of the high courts determined he should have been arrested. So I think that maybe to answer the question is because you haven't got that many cases now, because countries are not, even though the warrants are there, countries are not facilitating the arrest of people. So I think that's, what is the solution to that? How does one kind of improve that, obviously with discussion with all countries? And again, it's becoming more and more problematic, in particularly in Africa. We recently had a Commonwealth conference in Cape Town. A lot of African lawyers are saying, well, Africa is being targeted, but not the rest of the world. So I think that's another aspect, for debate. So, sorry, I'm just throwing a couple of issues and aspects that I've been certainly practicing as a criminal lawyer for many, many years. In fact, I think on our group, there's a lawyer that used to work for me. He now runs his own practice in Cape Town. These are all interesting aspects. But I think that, for me particularly, and others, it seems, the selection process. So one has to, if something can be sent out, how do we, if we've got somebody, if you're a lawyer from a particular country and somebody from that country gets arrested, I think you might have more chance of being appointed as counsel, co-counsel, or on the team that you've kind of been discussing. But if it's somebody from another country completely, you from country A, and how are you going to get appointed if the accused, either one or many others, are from country B or C or D? So, and maybe you might have a better chance if you from Africa than if you from a country, from some other country. So, sorry, I'm just throwing these pointers out there, but maybe particularly, how does one improve the prosecution or improve the number of people who are being prosecuted? I think it's something that we must all look at, because I suppose we're all looking at what's in the interest of justice, and if there are people being, committing crimes of genocide, that they should be prosecuted. But thanks for that. Sorry, I've sort of added a bit more on than what I should have, but and hopefully we're going to have more debate going here.
Yes, thank you.
Thanks.
No, thank you very much, William. And those are, long-standing structural issues, which, unfortunately, as the Bar Association, we're limited to what we can influence. But yeah, I think we all do keep those in mind as we practice internationally, or try to take international precepts into our national practices. So, Eugene, thank you very much. It's great to see you as always. And everyone, thank you very much for joining on behalf of the ICCBA. We hope it's been useful, and I believe we'll be advertising something for September. And it was really interesting hearing from everyone today. So thank you again.
Thank you.